Think twice before leaving that one-star Yelp review. Thousands of people every year are being slapped with massive defamation lawsuits simply for leaving a negative review of a local business. Can a company legally sue you for sharing your bad experience? Here's exactly what the law says about your online reviews and how to protect yourself. Every single day, over 57,000 reviews get posted on Yelp alone. The platform now hosts more than 308 million reviews, and nearly 95% of consumers read those reviews before making a purchase. A single one-star increase can boost a business's revenue by up to 9%. Meanwhile, a single bad review can cost a business 30 customers. With stakes like that, it's no surprise that businesses are fighting back, and they're doing it in court. As attorney Evan Mascagni, policy director at the Public Participation Project, puts it, most Americans don't realize they can be sued for writing an online review. With the rise of user-generated content sites like Yelp, TripAdvisor, Google, we've really seen a shift where folks are being sued for their speech online. So let's break down exactly where the legal lines are, what protections you actually have, and the real cases where ordinary people got dragged into courtrooms over a few sentences typed on their phones. The central question in any review lawsuit comes down to one distinction: fact versus opinion. This is the single most important thing to understand. Opinions are protected speech, even if they're harsh, even if they're unfair. Only statements of fact can be defamatory. Saying the food was terrible is your subjective opinion and nobody can sue you for that. But saying this doctor forged my medical records is a specific factual claim, one that can be proven true or false. And if it's false, you could be looking at a defamation lawsuit. To win a defamation case against a reviewer, a business has to prove 4 things. First, the statement must be a false statement of fact, not opinion, not hyperbole, not a personal feeling. Second, the statement must have been published to a third party, which posting it online obviously satisfies. Third, the reviewer must have been at least negligent, meaning they didn't take reasonable care to verify their claims. And fourth, the false statement must have caused measurable harm, lost customers, negative publicity, emotional distress. If all 4 boxes get checked, a reviewer is in serious trouble. And we're not talking about small trouble. Hiring a defamation attorney typically costs between $250 and $600 per hour, with specialists charging $750 or more. A case that goes to trial can easily rack up $50,000 to $150,000 in legal fees. Even cases that settle early run $15,000 to $40,000. Consider what happened to a Colorado couple in 2015. They left a negative Yelp review for a flooring company and ended up spending $65,000 in legal fees, including a $15,000 settlement payment. Or take Tom Lloyd, a Florida man who left a negative Yelp review for a veterinary practice in 2019 and was left with more than $25,000 in legal bills after the practice sued him for defamation. Then there's the Bigfoot case. In 2018, a tourist attraction in Branson, Missouri called Bigfoot on the Strip sued a Kansas man and his daughter over a TripAdvisor review. The man had given them 3 out of 5 stars, not 1 star, 3. The lawsuit sought at least $25,000. Fortunately, the man was granted summary judgment in 2019 and the case was dismissed, but not before he had to endure months of legal proceedings over a middling review. Now the good news: you are not defenseless. The first major protection is Section 230 of the Communications Decency Act, passed in 1996. This law shields platforms like Yelp and Google from liability for content posted by users. You can't sue Yelp because someone left you a bad review. The platform is immune, but the individual reviewer? They're not. The second protection is the Consumer Review Fairness Act, signed into law by President Obama in December 2016. This law makes it illegal for companies to include contract provisions that punish customers for posting honest reviews. Those gag clauses you sometimes see in terms and conditions? Illegal. The FTC brought its first enforcement action under this law in 2018. But here's the important caveat. Nothing in the CRFA stops a business from suing a customer for actual defamation, for saying something provably false that damages the business. The third and arguably most powerful protection is anti-SLAPP laws. SLAPP stands for Strategic Lawsuit Against Public Participation. These are lawsuits filed not to win, but to intimidate. The plaintiff doesn't expect to prevail in court. The goal is to bury the reviewer in legal fees until they delete their review and shut up. It's a bully tactic, plain and simple. Currently, 34 states and the District of Columbia have anti-SLAPP laws, and 2024 was a banner year with Maine, Minnesota, and Pennsylvania all enacting robust new protections. If you file an anti-SLAPP motion and it's granted, the business that sued you has to pay your attorney fees. California dentist Yvonne Wong learned this the hard way. She sued Yelp and a patient's parent over a negative review. Yelp won dismissal, the parent won too, and Wong was ordered to pay over $80,000 in attorney fees and costs. Trying to silence a reviewer cost her more than the review ever could have. Meanwhile, the legal landscape keeps evolving. Courts saw a 34% increase in internet libel filings between 2023 and 2025. The FTC introduced regulations in 2024, making it explicitly illegal to buy or write fake reviews, with significant fines for violators. Google blocked 240 million fake or policy-breaking reviews in 2024 alone, and Yelp removed over 185,000 reviews last year, with 81% of its legal threat consumer alerts stemming from businesses using gag clauses. And then there's the frontier nobody saw coming, AI defamation. In April 2025, conservative activist Robbie Starbuck filed a defamation lawsuit against Meta, alleging that Meta's AI falsely accused him of participating in the January 6th Capitol riot. As of now, no AI defamation case has reached a final judgment anywhere in the world, but the lawsuits are coming. So what should you actually do? The practical advice is straightforward. Stick to your honest opinion, describe your genuine experience, don't exaggerate, and don't make specific factual claims you can't back up. Saying, "I think the service was slow," is protected. Saying, "I didn't enjoy my experience," is protected. Saying, "The owner committed fraud," could land you in court. The difference between a protected review and a potentially defamatory one often comes down to a single word choice. The review ecosystem we've built is powerful. It shapes where we eat, who cuts our hair, which doctor we trust with our health. That power comes with a responsibility that most people have never thought about. You have every right to share your experience. Yelp's own senior vice president, Aaron Schur, has said, "Reviewers have a First Amendment right to honestly describe their experiences with local businesses." But the key word there is honestly. The next time you sit down to write a review, remember, your words carry legal weight. Be honest, be specific about your experience, and leave the provably false accusations out of it. Because in the age of online reviews, the line between free speech and a lawsuit might be thinner than you think.